in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption, split tight as it bites. In this endless trial, we pay the price.
Hey, yo, folks! Welcome to today's show, which is a bit of a downer because this coverage today is Mr Sledge, also known as Mounk Tounk. The state is trying to revoke his probation. Mr. Sledge signed a plea deal way back when, and which included that he had to testify in the Young Thug RICO trial. And when he took the stand and they started to read through the factual thingies, then it was revealed that a good portion of it was added by the prosecution, written down by the prosecution with more or less zero input from Mr. Sledge. And then they pulled a fast one. And after the final draft and the thing that got signed, they added things, which his attorney, Mr. Wright, said, I don't know how I missed that, but I did. So, in my opinion, Mr. Sledge was as truthful as he could be on the stand a few weeks ago. And now the prosecution wants to punish him and then, of course, set an example for the rest of the plea dealers who are upcoming in the YSL trial. Currently waiting now for that probation hearing to start. I have 3 channels. 11 Alive, Fox 5 Atlanta, and Law and C-Word. Now, Law and C-Word is the only one with closed captions, so I prefer that one, even though they have these damn banners. But if not, 11 Alive or Fox 5 Atlanta, it will be the choice, depending on which one has the better sound. So that is what we are waiting for. And Kristen just got here from Kat. I think Kat is streaming this one too, and perfectly understandable, because this is one of the more important aspects of the Young Thug RICO trial. Because if Judge Whitaker chooses to revoke Mr. Sledge's probation, then this will have impact on okay. Let's see here. They seem to okay, Law and C-Word is up and running. but it is this one with some weird noise in the background. So I'm pulling that one. I'll see if Eleven Alive have their pause music on. Fox 5 seems to, as of now, have the not as effed up sound, at least. So with the choice of good audio and closed caption, I have to go with the better audio. So we are waiting for this to start. Now, one aspect that let's see here. There. That oh hey, Erin Olivia, thank you so much for your $5 super chat. Hit the likes, y'all. Hi Nick. Hi Erin, and thank you so much. Thank you so much. Thank you for your support of my channel. Thank you. Now, one aspect here could be that in every case, in every trial, in every charge as of now, there could be negotiations going on in the background that we do not know about. I'm not sure if this is what is happening, or if it will be happening, or if they, Mr. Wright and Mr. Sledge chooses to take their chances with Judge Whittaker. I don't know, but I will leave that as a possibility, at least. That because 30 years is a long time. And if the state shows up with an offer of, all right, revoke probation, but we are only asking for 5, and you sit 2 years, and you still have to testify in the upcoming trials. Who knows? I'm just leaving it out there as a possibility. I'm not saying it actually happens, but negotiations are often ongoing in these type of matters. What if Sledge doesn't show? Warrant for arrest? Oh, if he doesn't show, he's screwed. So I would assume he is showing up today. And the reason why I say it can be a possibility with negotiations is Judge Whittaker is always on time, and we are currently almost 10 minutes late. Because if she says it's 4 p.m. start, it is a 4 p.m. start. Now, since I am covering this probation revocation hearing, the recap of today, tomorrow. And there was interesting developments today in the Young Thug RICO trial. For instance, you had Mr. Sprinkle, the Hobbit prosecutor. Oh, the Hobbit prosecutor admitted on the stand that he never considered Mr. Williams as even remotely as a suspect in the Nut murder. That is huge. But then again, the prosecution pulled a fast one and they called another gang expert who was proffered and admitted as, yeah, I can interpret lyrics. So it will be really interesting to go through that tomorrow. The starting time tomorrow will be 9 a.m. Eastern Standard Time, just as usual. So I hope you all can be there. I hope you all can be there. Well, I'm saying 9 a.m. as of now. I'm having Friday panel show at 7 p.m. today. And I don't know how long that will go on or how much alcohol is needed. I have no idea. I have no idea. But here is Mr. Sledge with his attorney, Mr. Wright. And yeah, he chooses to continue with Mr. Wright. Me personally, after Mr. Wright's testimony, if I was facing 30 years, I would throw my lawyer under the bus in a heartbeat. I would get another lawyer to throw my previous lawyer under the bus. I mean, he might be a family friend and everything, but 30 years, yeah, I would throw him as far as I could. Now, do I believe Mr. Wright is a bad lawyer? No. I do believe mistakes were made. And if you're facing 30 years in prison, those small mistakes could save you from severe prison time. Okay, we are about to start. Okay, sound please. Sound please. Oh, for the love of all that's holy. Pooled feed, come on. Sound. Sound. No. There is no sound on either. So this is the pool feed that for some screwed up reason, come on. Oh, love. Oh, Adrian Luttrell, love.
All right.
Here we go.
This is a probation revocation matter.
Yes, Judge. State filed a notice of a probation revocation for the defendant as to his violation of the special or a special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for your honor with the certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read, and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true, and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant. If Your Honor wants to preview it or wants to be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the.
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that.
So,
Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
yes, I'm very much aware of that. The transcript obviously is not ready as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably work.
Yeah, you're overwhelming everybody now, including because the YouTube streams does not include sidebars. That is why she can only take judicial notice of the testimony, but it's not the official transcript, because the official transcript will include sidebars.
Working hardest out of everyone in the courtroom. So I knew Your Honor
All right.
either could take judicial notice
Thank
or
you.
rewatch it. Can I approach it?
You may.
Yeah, the interference in the sound, I can't do anything
And
about
can
it.
you- can you
That
try
is
to
the
use a
full
mic,
feed.
please?
Yes, Your Honor.
Can I back out of the court reporter?
Nothing further from the state at this time, Your Honor.
All right.
Oh, really?
Mr. Wright,
Your Honor, may I remain seated or?
it's probably easy. You can. It's probably easier to hear you
Okay.
that way.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your exhibit 6? I think I
Well,
only got 5.
exhibit 6 is the one thing, and that's just a listing of my emails in December between
Oh,
myself
that's
and
this
Ms.
one
Love.
page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
That's fine.
So succinctly, I thought it best to submit these exhibits. When you look at exhibits 1,
And
2,
those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah, and I
Now,
recall we discussed this during the trial of this, the ongoing trial as well.
yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to, you see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was defendant's exhibit 4 that if you look on defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here. I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on defendants 4, use this one.
But are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will take
testified to.
judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
I'm not sure about that. That may be your contention, but
well, we would contend to the court that where my actual email defendants 2 clearly denoted that.
it does not. It is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So.
Yeah, I have to say, this is the very reason why I believe Mr. Sledge should have gone with another lawyer. Because what Mr. Wright here is testifying to or talking about is his mistakes. Mr. Sledge relies on Mr. Wright to get things right. And he didn't. So he needs, I can't emphasize this hard enough. I believe in order for Mr. Sledge to avoid getting thrown in prison is to throw Mr. Wright under the bus, because this is Mr. Wright's mistakes. And I think he would have a better chance with another lawyer, because Mr. Wright is also, he has an interest in keeping his bar card. He has an interest in keeping his practice. He is more or less a party opponent here, according to his own testimony during the trial, that he made a mistake. He didn't read the final paper. And that is huge. But it seems like Mr. Wright has been Mr. Sledge's attorney for so long that Mr. Sledge keeps trusting him. And in this case, I believe it's a mistake.
But your response on your defendant's exhibit to what is then item number 4 does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it, and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to, that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Yeah, again, I repeat myself here. Yes, Mr. Sledge is not a wealthy person. He is contrary. He barely scrapes by. But I do believe if, with all the community around here, which he knows about, and I think that someone somewhere would have taken this case for him. But he trusts his lawyer, and I believe that trust is misplaced at this moment in time. And I say it again. Mr. Sledge's one big defense against this is throwing Mr. Wright under the bus. He relied 100% on Mr. Wright getting this correct. And Mr. Wright didn't. Mr. Wright failed him. They made assumptions that he was supposed to explain this during court. He signed this and then explained it. If it's not on paper, then it doesn't exist. That is the difference between Mr. Wright's plea deal with Mr. Sledge and how Miss Merchant did a plea deal she did with Mr. Arnold. And it's so sad to see that there is a path for Mr. Sledge to get out of this. But that path he's not taking.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
Exactly.
However, in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood. Understanding it's not in the written plea agreement, but it was understood.
Again, I've been doing labor law for 30 years. Oral agreements are you can rely. There are a legal recourse of oral agreements, but they are so much harder if the opposing party isn't cooperating. And now the opposing party here wants to throw Mr. Sledge in jail or in prison for 30 years. You need to put those things on paper.
And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after what was that, December of 22, was now for the first time being drilled or asked questions rather as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right. Anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that.
Or that seems to, they have filed their paperwork, they had their arguments, and now, yeah, we are probably reaching the end of this
Officer,
hearing.
if they would like to be heard as well.
Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right.
relates to.
You know what?
probation.
I think I'm still on Zoom. Yeah.
This doesn't look good
And
for,
what's the officer's name?
it doesn't look good.
John. Oh,
We can
Oh.
hope, but
it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Hello, Judge Whitaker.
Hello, I'm trying to, oops.
I understand,
I'm trying
Miku,
to get
but you
myself
should
on
scream
video.
at
Oh, okay.
Mr. Sledge's attorney.
So that
Judge
it's not a
Whitaker might
disembodied
not have a
voice.
choice in this.
Hang on. All right. Hello, Officer Jobby.
Hello,
to see you.
Judge.
All right, what is probation's, can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's
The
lucky of
DeKalb,
him, since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04 CR 24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04 SC 23883. That's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was adjudicated guilty.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So hang on. So the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them now.
Okay.
Yeah, I agree with Dave. The underlying issue here, which we sadly can't do anything about, is that Mounk Tounk did his time. I mean, the crimes he did all got caught. He was charged and he has convictions. But then RICO, and everybody is recharged with the same crimes as overt acts in a RICO. And that is on the lawmakers that made this happen. But in this specific
Are
case,
you looking about prior?
in my opinion, it is Mr. Wright, Mounk Tounk's lawyer, failing Mr. Sledge by relying that the prosecution would somehow again, his best recourse here should have been to throw his lawyer under the bus, and he isn't.
Or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by convicted felon, the
I
15
figured
SC.
there had to be something else there. Okay,
I'm sorry, I should have spoken sooner. I apologize.
appreciate it.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts to make that decision.
Okay. All right, well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
Yeah, there it is. She finds, yeah. She did a finding that Mr. Sledge violated his probation. Now she's searching for recommendations from the state as to what will happen.
Candor to the court, Your Honor. I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case. And I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
It's not the
Or
request.
is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years. So he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number.
Okay.
Ramona. That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Your Honor, if it'll please the court, I understand the court's ruling that there's a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and I had to recover from that. So we would ask the court to consider some restrictions first, as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgements, and sentencing acknowledgements, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation, but I also appreciate the fact that some of the many reasons why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So.
In all honesty, just being revoked 5 years with his horrible lawyer is kind of a win. He could have faced all of it. But being just revoked 5 out of the 30 years, yeah. during these circumstances, I can't say that, well, during all of these circumstances, yes, it's not fair. It is not fair because we know the evilness of this prosecution. We know how they lie and cheat all the time. But Judge Whittaker here, in my opinion, her hands are tied. There is case law backing her. She could have gone for the full 30 years. And she didn't. She only revoked 5 of them. Probably the best outcome, considering he didn't fire his lawyer, he didn't throw his lawyer under the bus. It could have been so much worse. So much worse. But it's still really, really bad that Mr. Wright, his attorney, failed him this hard. I do believe revoking 5 of his probation is the time he needs to spend in prison, and then 25, and the additional 25 years will be probation after he served his time. I might be wrong, but I don't think so. But yes, he is going to prison. Sylvia Edwards. Meanwhile, Fanny skipped out of her subpoena. Yeah. Bonnie Willis, who lies in church, who lies in court records, in my opinion, who is actively hindering justice in her disqualification case. She gets away with it because she has this prosecutorial misconduct immunity. During the circumstances are horrible for Mr. Sledge, and the underlying issue is the RICO, the Georgia RICO Act, which allows the state to recharge Mr. Sledge for crimes that is already been through the system. It is inherently unfair, and that is on the lawmakers. But with all of this, 5 years, I think that is the best Judge Whittaker could do for Mr. Sledge.
That's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And he will be continued on probation, Your Honor?
And reinstate the balance.
Your
Thank
Honor,
you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So
Yeah.
no, I'm sorry.
Yeah,
All right,
he
court is
is
adjourned.
going straight to prison.
Good seeing you, Judge Whittaker.
Yes, thank you. Good to see you.
All right.
The only person we could hear was Miss Jolly, so. only
Yeah.
person we could hear was Miss Jolly. Not on Zoom.
So Sledge's attorney makes a huge mistake relying on the state. And Dave, Mr. Sledge had a plea agreement. In that plea agreement, he made factual statement under oath in a hearing. In trial, he went back on several of those factual statements. And now his probation, 5 years of his probation is being revoked. So he's spending 5 years in Georgia prison. And then another 25 years of probation after that. Yeah. Mr. Sledge's attorney gets to get home. And Mr. Sledge goes to prison because Mr. Wright, in my opinion, failed him monumentally by trusting the state, by not listening in the plea hearing in court by not listening or reading the paper. Actually reading the paper. So under all of this, yeah. Really? I'm not entirely sure. Revoking 5 years. For me, revoking 5 years of his probation, I don't know. Maybe it's a language issue here. Dave, get in here. Dave, get in here. I need a US-based lawyer to yes, I know you're there. I meant here, if you can. If you can. Can you give... here he is. Hi, Dave.
Hello. Okay, so
Yeah.
what's your question now?
Yeah, I think I have a language issue here. The judge's sentence here is he had 30 years probation on the line. He spent 2 years in jail, so that is accounted for. She
Okay.
revoked 5 years of his probation. Does that mean he spends 5 years in prison or 25 years?
That in my opinion would be that he's going to spend the next 5 years in prison. Most often you get like a suspended sentence, like you're sentenced to so many years in prison, but we're going to suspend that for a certain amount of time and order you on probation for a certain number of years. And then if you revoke that, then you go back. So I think he's going to lose 5 years of whatever term that he got, and then he'll probably go back on probation again.
Okay.
That's what it sounds like to me, but I'm not a Georgia attorney. So
Yeah.
he'll go for 5 years and then get out and be on probation again.
Yeah, Katie, judge gave him 5 years in prison. He already done at least 2.5 of them. No, she did a reset of the probation. He spent a number of he spent 6 months in jail before the plea deal, and then
Okay.
it took almost 2 years for his testimony while he was out. So he had 2 years of probation already. Before
Yeah,
he
but the 2
testified.
years of probation is not going to count towards any sort of jail stint.
So he already spent. Yeah, so I do believe
you only get credit for time in custody, not on probation. So whatever he was in custody, he might get credit for that, but that's it.
Yeah, so 6 months, so 4.5 years. Maybe he will be let out earlier. We don't know.
It's probably not, because although they have, certain states have good behavior standards. I don't know if Georgia's one of them, but let's assume that they do. A term of 5 years with a tail of probation and suspended sentence usually doesn't get you out early, unless this is for his plea. Is it a violent crime? The underlying crime?
The underlying crime is the underlying crimes are what was it? Gun as a felon, I believe, and armed robbery, something of the sort.
So it might be because it's considered a violent crime, he might not get off early.
Yeah.
But again, I'm not a Georgia attorney. I'm just trying to think of how it would be done in Michigan. So with 5 years on a violent crime with a tail of probation and a suspended sentence, essentially, they wouldn't let you out early in Michigan. So that's just kind of what I'm basing it on. So
yeah,
go ahead.
The plea violation is not considered a violent crime.
Yeah, I did hear that. So the actual, it's not like he violated probation because he strong arm robbed somebody or something like that. He violated it because he breached the terms of the plea agreement, and so
Yeah,
that's a non-violent violation.
Yeah, and I don't know if you listened to this, but or heard it, but during the plea hearing back in December of 2022, the state, from the final draft to the signing in court and reading, they changed the items in and added things, and his attorney didn't catch it. Not on paper, not even when they were read out loud in court. He didn't catch it. So
Yeah, it's
for me,
bad.
it's really bad. And I understand why a person like Sledge, with barely a high school education, 9th grade, I think he left, he relies on, he had this attorney for 15 years.
Yeah.
And I think his best recourse in front of, with facing 30 years of this, would to throw his attorney under the bus.
Are they going to try to charge him with perjury now? Because that's a 10-year felony.
Yeah, she mentioned that she almost considered this a perjury.
Yeah.
Not a technical violation, but she is more on the face of perjury. So
Yeah.
you never know. They might charge him with perjury as well.
I mean, I'm looking at this even from like a civil standpoint. Like, dude, you promised to do one thing and you did another. That's a breach of contract. I'd be pissed too if I was the prosecutor. But at the end of the day, I think she's just doing this because she's just because she's just an evil person.
Yeah. Yeah. Oh, yeah. But yeah, and this sets the tone for the rest of the witnesses with plea agreement as well. Because the first 3 with the plea agreements, they haven't gone after, but they still have the option to. I mean,
yeah, and there's that one guy. What's his name?
Woody.
Woody. Yeah.
Yeah.
Woody's got to get something. He needs to get out of town. That's what Woody needs to do. Woody needs to go to the other side of the country and just hang out for a bit. Get out of Georgia, man.
Yeah. And as Brenda said, because he told the truth. Well, here's the thing with law. If you swear to something, even though he didn't read the plea agreement back in December of 2022, he swore to it. And then now in September, he told a different story. I do believe he was telling the truth in the trial.
Now, here's my thing, though. Was it materially different, or was it like more or less the same? No, it was materially different.
Yeah. So they went through that plea agreement, and I believe 3 or 4 he completely said, "I never did this."
Okay.
But he did swear to it back in. And that, I believe, is on his attorney.
Yeah. No. So his attorney sent or gave him a plea agreement and said, "Hey, you sign this, you get out." And he was like, "I don't care what it says. I'm signing it. I'm out." That's exactly how this happened. He's like, "I'm not reading this. I don't care what it is. I'm out. If I sign this, I'll sign it."
And then at the hearing, his lawyer sat there listening to the reading of the paper and still said nothing. And as Mounk Tounk on the stand, I mean, he can barely read. He relied 100% on his attorney.
You know, this is part of the problem too when I talk about overcharging people. And I know Andrea Burkhart has gone on sort of a thing about overcharging people or just charging too many people. They charge everybody. They can't possibly have a trial on it. So then they strong arm you into making a plea deal. And that plea deal could be something as simple as signing a document and getting out, or it could be stacking, 20, 30 charges on top of you so that you plead to one. It's a whole racket. The whole criminal justice system is a racket.
Yeah, and as I said earlier, the underlying issue here is that RICO circumvents double jeopardy, because everything that Mr. Sledge pled to has already gone through the system once before. He has convictions charges has been dropped and stuff like that, but they can retry everything as overt acts under the Georgia RICO Act. And that is
Really?
and it's morally unfair, but this is how the lawmakers wrote the RICO Act.
Everyone has like a different amount of time that he served. So I just want to reiterate, there's a difference between in custody and on probation. So if he was in custody for 6 months and on probation for 2.5 years, then he gets credit for the 6 months. If he was in custody for 10 years, then he gets credit for 10 years. But I don't think that's the case.
Okay, Sean Wilson, why would you sign something you don't agree to?
To get out of prison.
To get out of jail. I mean, Rice Street is a cesspool. And his mother was dying. He has had at that time 8 kids and a grandkid on the way. I mean, yeah. If you've never been in jail, it's hard to understand why you would sign something you don't agree to. If you have been in jail, you can understand. And he relied on his attorney.
Yeah. Yep. So, alrighty. Well, I hope that answered your question. I'm getting back to my appellate work now.
Yeah. Good luck on that one. I had a good time watching you prepare.
I'm still reading the same stuff. I have stacks of paperwork everywhere. It's just, I have 16 transcripts, over 100 court filings that I'm reviewing on a case I'd never touched before. So you got to like learn it all. Anyways.
Yeah.
All right.
Yeah.
You guys have a good one.
Thank you for showing up.
No problem.
Thank you. See ya. And we got greeted by Mr. Jingles. Hello, Mr. Jingles. Well, this is a travesty. It is not fair. It is morally it's morally unjust. But just being revoked 5 years is, I believe, the best Judge Whitaker could do for him. And yeah, I feel so sorry for Mr. Sledge for relying on Mr. Wright. Yes, I know Mr. Wright's health issues going up to that, but with those health issues, he should have the fortitude of saying, I cannot represent you in this. And he still did. And then he went into that plea hearing in December of 2022. They said all the things out loud, and he still didn't react to it. If I do not give legal advice, but for Mr. Sledge, you need to change attorney. Because in my opinion, it was your attorney's mistakes that put you in jail. Even though the underlying issue is the Georgia RICO Act being morally unfair, it's legally, it's there. All right, folks. Sadly, but Mr. Sledge is probably on his way to prison now. And there's not much we can do about it. I will be sending you off to the Friday panel show. It starts at 7 p.m. Eastern time. So you have almost 2 hours to get a snack, drink of choice, and stuff like that. And what else can I say? Hug your family, folks. Unless your family is crap, then screw them and give your love to the people who deserve it. All right. I will see you in about 2 hours. Bye-bye.
In the courthouse where time stood still, generations pass on the hill. Prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight. Came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as it bites. In this endless